Right, let's proceed.
Mr. Chief Justice, and may it please the Court. It is fitting that this Court reconsider this case and the important constitutional issue it presents against the backdrop of the tsunami which recently struck our criminal justice system. As the United States Supreme Court has told us repeatedly over the past few years, since Melendez-Diaz, forensic laboratory evidence is not inherently reliable and somehow exempt from being tested and challenged at trial through the crucible of cross-examination under the defendant's right of confrontation. As we now know in Massachusetts all too well, forensic laboratory evidence is vulnerable, extremely vulnerable, to bias, sloppiness, manipulation, and just plain fraud. Yet, under this Court's recent jurisprudence, which has remained essentially unchanged for the past quarter century in this area, the Commonwealth can effectively insulate the work and test results obtained by a laboratory analyst through the simple expedient of presenting a substitute analyst at trial to get those same results before the jury under the rubric of a so-called independent opinion, which is derived entirely from those test results which were obtained from somebody else out of court who never is subject to cross-examination.
Well, I'm just curious, what would you say we should do if the person who does the analysis dies and they're not available to confront? Well, does that mean the defendant is declared not guilty?
Your Honor, of course not. As with any other witness at any other criminal trial, witnesses die. Witnesses become unavailable. That's part of life. That's part of our system. This particular type of evidence, which is so critical, which juries pay so much attention to and give so much weight to, should not be put in some special category exempt from the same issues that pervade every other kind of evidence. So yes, if an analyst dies, maybe the material can be retested, and another analyst can do the work and testify. Maybe the raw data is still available in the case of DNA, where the raw data is the raw electronic data is the critical element in analyzing DNA evidence.
When you say
Yes, no, you go ahead.
If the raw data were available, then wouldn't that fall within the U.S. Supreme Court rubric and permit a substitute analyst to review that raw data and then come to his or her own conclusions and opinions based on that raw data?
Well, Your Honor, people disagree about that, but I happen to think that probably would fit within the rubric. I think that you can draw the line any place you want, and this Court is going to have to wrestle with that. But wherever you draw the line, somebody has to review the raw data, the unfiltered data that justified those allele calls, and that person has to testify. That's what, and I think the Rhode Island Supreme Court decision, the post-William decision in Lopez, which was cited by the Commonwealth and which I talked about in the reply brief, is extremely valuable in really explaining better than I could in my briefing how critical the raw data is. That's where the rubber meets the road. That's where the analyst looks at the peaks and basically decides which ones to filter out, which ones to treat as alleles, which ones to treat as artifacts.
I should know this and I don't, but if the raw data is available, wouldn't that be available to the defense expert?
Yes, the raw data is normally available to the defense expert.
So I guess why wouldn't that be a solution?
Well, because under our system of criminal justice, the defendant does not have any obligation to present
that fact,
anything.
but you talked at the outset about how the Commonwealth gets to insulate from review, and it sounds like that's not, at least in the DNA sphere, that is not true.
Well, they do, Your Honor, because if a call, an allele call is made, in this case by Wendy McGee, and based on raw electronic data, and Wendy McGee is not in court. Robin Cotton is not in a position to say, why Wendy McGee made that particular call, whether she filtered out particular peaks or whether she didn't filter out particular peaks. She could be asked about that on cross, and in fact, she was asked some of those questions on cross, and her answer was basically, I can't tell you that. I don't know how deeply the analyst looked into the data.
Did Dr. Greineder's experts in the DNA field do repeat what Wendy McGee had done based on the raw data that I assume they obtained?
Dr. Greineder's experts did look at the raw data, but in fact, Judge Chernoff did not allow defense counsel to cross-examine Robin Cotton using that raw data other than through hypothetical questions, because the raw data wasn't in evidence. So it was brought up in an extremely ancillary, ineffective way on cross. And the fact remains that it is the obligation of the Commonwealth to prove its case, to present its case through a witness who's subject to confrontation, and that was not Robin Cotton.
But it sounds like you're disagreeing actually with Justice Duffley, because or is your criticism not about Dr. Cotton's opinions, but because she spent a fair amount of time speaking about the what Wendy McGee had done?
No, Your Honor. It is the bifurcation that this Court has latched onto, saying the underlying data is different than the opinion, is really it's a phony bifurcation.
And that's really at the heart of your argument.
Well, it is,
right?
Your Honor, because there is no opinion. There is simply what are the allele calls, how many of those allele calls match the defendant, and then running a computer software program that spits out a number. I mean, there's no opinion there. That is the analysis done by Wendy McGee. That is the analysis that's in her reports, and that is the analysis that was reported to the jury by Robin Cotton. So yes, I mean, I think I answered Justice Duffley's question the way I wanted to, which is if the Commonwealth presents some other witness who's if Robin Cotton had said, look, I analyzed all the raw data and unfiltered, okay, I went through the same process that Wendy McGee did, and I made those allele calls. I confirmed all of her allele calls, and in my judgment, all of her allele calls are correct based on the raw data. I think I've got a tougher argument that that's not good enough.
If Dr. Cotton had reviewed the raw data and then instead of putting it into a computer, made her own handwritten calculations as to the statistical likelihood, and then expressed her opinion as a mathematician, or is somebody familiar with statistics as they apply to, genetics, would her opinion meet with your requirements?
Well, if you want to call it an opinion, sure. To me, a mathematical computation is not really an opinion.
Well, it's outside the expertise of a jury.
Well, that's true, Your Honor. So yes, if she essentially duplicates the work done by the analyst, that is, she looks at the raw data, she confirms the allele calls, she confirms that the arithmetic is done correctly, whether she does it by hand or does it by computer, I think I'm hard pressed to say that's not good enough. But that's a far cry from what happened in this case. None of that happened in this case. She didn't see the raw data. There's no evidence she ran the numbers herself. And she was essentially parroting what was in McGee's reports, using big charts and graphs to show the jury what the allele calls were. And getting back to Justice Botsford's question, the idea that's somehow an opinion as opposed to the underlying results is laughable. And I think Justice Kagan's dissent rejects that bifurcation. Justice Kagan's dissent basically says treating the underlying data as somehow separate, as merely a basis for the opinion, doesn't hold water. And Justice Thomas agreed with her.
Now, you have in Williams the Supreme Court affirming a conviction where no one from Cellmark testified. Right. And they remanded here, and here the director of Cellmark testified and was available for cross-examination with all of the work notes of Ms. McGee. So how can we say that in light of Williams, where there was no one from Cellmark, and that was okay, that it's not okay here where you had the opportunity to cross-examine the director of Cellmark who had all of the work notes available for cross-examination?
Well, Your Honor, I think that I start with the critical differences between the facts in Williams and the facts here. The fact that, other than that Cellmark was involved in both cases, that the cases are drastically different.
Are the reports the same?
There was a Cellmark test in Williams, and there's a Cellmark test
No,
here.
I know, but I mean, are the reports essentially identical?
Sure.
And they're no more formal than Justice Thomas.
I agree. If this court, like the Commonwealth says, all Williams means is what Justice Thomas says, that if you don't have a blue ribbon or an attestation, it's not testimonial, I lose, okay? I agree with that. But here, unlike Williams, there was a targeted individual. Greineder was the suspect from day one. His fingernail clippings were obtained. They were sent to Cellmark to be typed. Wendy McGee typed them. She then, after that, looked at the key pieces of evidence, the low copy number DNA, and made her calls. That is totally different from what happened at Williams.
Does that go to the primary purpose part of the majority opinion, of the plurality opinion? So you're saying that it doesn't work because it doesn't meet the plurality
Right,
opinion
Your Honor,
test?
it flunks that test cold. It's
Well,
exactly
it flunks the alternative it flunks the alternative test of the plurality opinion. Right? In other words, the plurality opinion seems to be saying, look, it wasn't admitted for the truth. It was the basis of, under federal rule of evidence and Illinois rule of evidence, it was the basis of the Illinois expert's opinion, so that's okay. And then went on to say, even if the Cellmark report had been admitted, it would have been okay because it was an unknown suspect. So it's sort of the alternative.
That's correct, Your Honor. But 5 justices clearly disagreed with the first argument. That is, it's not in for the truth. The 4 Kagan dissenters and Thomas all completely reject that reasoning, and so that's 5. And then with respect to the second argument, primary purpose, it flunks primary purpose. That's 4 justices. It flunks Justice Kagan's test on testimonial. So you have 8 justices. Other than Justice Thomas, who doesn't like the fact that there's not an attestation, who I submit would say that this violates the Confrontation Clause, and I submit that's a pretty good explanation for why they vacated and remanded.
Can I just ask you a question, though, about that? Because I think we could agree on the fact that Williams is almost impossible to understand who's saying what, but putting that aside, I thought that what at least Justice Alito thought Justice Kagan was saying was the problem was that it was the information that this was DNA sample taken from the victim and a male sperm on that DNA sample. That was the issue. It wasn't when she said, yes, there is a match between these 2 samples.
Well, I think
that was an opinion, and nobody was taking that one on.
nobody took that one on. That was not really at issue in the case. I think Your Honor is correct. But the rest of it she saw as testimonial. And here, the allele calls, the degree of match, and the statistical calculation of that degree of match is all I submit clearly testimonial.
Okay, so if it fails the primary purpose test, then the raw data is testimonial evidence. Yes.
Well, the raw data, and I submit the so-called opinion, which is not an opinion at all, also fails that test.
But now, do you mean the match? Is that what you're calling the opinion?
I'm calling well, there is no match as such. There's
that's what she said.
There's a random match probability. There's a number that says that in the random population, 1 in, say, 1 million people would have these same 8 combination of 8 alleles.
So if Dr. Cotton had confined her, if her testimony had been confined to her credentials, her responsibilities and duties at Cellmark, and if she is then described categorically the materials that she reviewed and was then asked a question based on your training and your experience and the materials that reviewed, do you have an opinion as to whether or not the sample that was found, there's any significant statistical correlation between the sample that was found? And she says yes. And what's your opinion? My opinion is that it was a statistical match of 1 in 24,000. What's wrong with that?
I think that's a great question, Your Honor, because I see that as another way the Commonwealth could try somehow to circumvent this confrontation problem they have. I say two things. Number one, I think what this court has said in cases going back to like Kernan, they said the contrary, which is talking about a match without talking about the statistical significance, it doesn't mean anything to the jury. And I would submit the converse is true too. Saying there's a statistical significance without explaining why is really not something that a jury can reliably consider, because it doesn't mean anything. And if they were allowed to do it, it still wouldn't have any real meaning to the jury. It wouldn't have any weight because it's not based on anything.
But your rule would apply to autopsies as well. Somebody reviews autopsy photographs, autopsy report, and the doctor gets up and expresses an opinion, reads the witness statements that somebody was shot, point blank. Everybody agrees that this guy was the shooter. You could not get a forensic pathologist could not give an opinion
No, Your Honor,
unless
I
he
think
performed the autopsy.
if you have a case where cause of death is hotly contested, I would have a problem with a pathologist coming up saying, I reviewed everything and I think the cause of death was poisoning, and sitting down. I think you have to have a foundation for an opinion. The foundation are the results. The foundation are the illegal calls. They're inextricably connected. You can't divorce one from the other. That's really what this court has said in talking about DNA. The jury needs to hear both what is the evidence and what is the significance of the evidence. Otherwise, this stuff doesn't mean anything. The only person who can present that combination of information is the testing analyst or somebody who replicates exactly what the testing analyst did by reviewing the raw data and doing the mathematical calculation.
I'm sorry.
I was going to say, so in an autopsy, the pathologist dies. The case comes to trial 10 years later. You can't get a substitute pathologist, so what you have to do is dig up the body and do another autopsy.
Well, no, maybe somebody could review the photographs. Somebody could review the toxicology reports. I think there's ways of doing it. There may be a rare case where a case can't be retried, but I think to throw out the confrontation rights of tens of thousands of defendants because you're worried about that particular weird case, I think would be grossly improper, and I urge the court not to do that.
Now here, though, there was no objection to the testimony of Ms. Cotton.
Yes, there was, Your Honor.
Only as to the presentation of facts. He
Your Honor,
didn't
I
say when she
disagree.
was calling Ms. Cotton to say, wait, I don't want Ms. Cotton to give an opinion. We already found that there was no objection to Ms. Cotton's giving an opinion.
Well, Your Honor,
are you saying
I-
we're wrong as to that?
Yes. Respectfully, the objection was Dr. Cotton started talking about the test results, and defense counsel went to sidebar and said, I object, I'm paraphrasing, to Dr. Cotton testifying about the test data in this case.
Right.
To me, that
and we-
doesn't mean he's
and we
only
found-
talking about the illegal calls. He's not talking about the statistical significance. It's a unitary objection. She shouldn't be talking about the DNA testing. She had nothing to do with it. I think it's wrong to say, well, to parse that objection that finely, I don't think is fair.
Okay, so you're saying that even if she had gone over the work papers and reviewed all the raw data and said, here's my
The
opinion.
raw data. The raw data is not in the work papers.
What is in the work papers?
The work papers contains the printouts of the electropherograms, which are filtered, which Wendy McGee has already, as Dr. Cotton explained in her testimony at great length, and as Dr. Eisenberg explains in his affidavit, she's filtered out the peaks that she's not looking at, that she's not counting. Dr. Cotton never saw those peaks. They're not in the work file.
So let me get clarity about this. The raw data was available to the defendant because the defendant could give it to his experts, and you had your own expert opinion based upon your own analysis of the raw data, but you weren't allowed to cross-examine Dr. Cotton about the raw data based on the analysis done by your experts.
Other than through hypotheticals.
Other than through hypotheticals. Okay, so there was raw data and you had it, but Dr. Cotton didn't have it.
Of course she had it. She could have looked at it. It was on a CD. She had
So
access
she
to
had it, but it
She-
wasn't in the work papers that she said she reviewed.
That's right. She said she never reviewed the raw data. That's in her testimony.
Mr. Sultan, we'll have to leave it there.
Thank you, Your
Thank
Honor.
you.
Good morning, Your Honors. Varsha Kukafka for the Commonwealth. This court's rulings on the DNA testimony is solidified and confirmed by the Williams versus Illinois decision.
Tell me how you're going to try this case. If you were to retry this case and the analyst, with the same evidence, the same people, analysts not available, you've got Dr. Cotton. How are you going to retry it after Greineder and after Williams?
After Williams versus Illinois, an opinion may be offered without violating the confrontation clause.
So explain how you're
Crawford-
going to get the DNA evidence into evidence.
Crawford does not bar opinion testimony. The opinion is subject to cross-examination. And Crawford does not bar the Cellmark reports because those are not solemnified, formalized.
Oh,
Oh, that's not going to get
no,
very
that's
far.
So you think that the next time you don't need even to call somebody from Cellmark, and you think that's going to pass here?
you're just going to say Justice Thomas says this is okay?
Well, I'm not suggesting that the report would go in, but the opinion.
Is that what you
of-
just said? That it was admissible?
The themes of Williams are that DNA evidence is reliable and it should be encouraged to be, it should not be made more difficult to admit at trial. What you have to do is take this from Crawford and the effect that Crawford had on the confrontation clause, and then the line of cases, Melendez versus Diaz and Bullcoming, those were certified reports. They were notarized.
Well, what's the difference between, if we had a drug certificate with an analyst, this is the Bullcoming case, a drug certificate that says I certify, I attest that this is what I weighed this stuff and analyzed it, it's cocaine, it's X number of grams. You can't get a substitute witness, right? Because they're really just repeating what's on that test. Let's erase the certification and call it a report instead. Could the drug analyst get up and say, I've reviewed the materials in this case and the what was done by the foot soldiers, and it's my opinion that this was cocaine and it weighed X grams?
Well, that would be the Minoz case, which has been remanded. But the Bullcoming, you have to understand, that was a state laboratory, and the person is already arrested, and then their blood alcohol is taken.
So if we use a state DNA lab, we won't be able to we will have to present the DNA analysts. We won't be able to rely on a substitute examiner.
No, not because of that one reason. I'm just pointing out the points in Bullcoming that even though the report was not certified, there was information on that report that referred to certain court rules and the admissibility of blood alcohol, somewhat similar to the Melendez-Diaz certifications. Cellmark reports are different, the Williams decision said. And the point is that the safeguards that the Williams versus Illinois decision said are that a person would not act strictly as a conduit. And certainly in this, as I said in my brief, as this court already found, Dr. Cotton did not act as a conduit. You cannot have someone up there testifying for 3 days with her expertise, with her memory of certain profiles and peaks and so forth, that this person is merely reading off of a report.
Can I ask you about that, though? I mean, I somehow understood that was the report, the Cellmark report, available to us when it was here on appeal?
I do not believe no, I don't think so, unless it was included with the motion for new trial.
So we couldn't compare what Dr. Cotton said
I think
to
it
the
was
report?
included in the motion for new
If it
trial.
was
It was
included with
included in the motion for the new trial. Okay.
The fact that her description of certain profiles was the same as what was in the report does not mean she's acting as a conduit. She spent the time, she applied her expertise and knowledge to go over and including electropherograms and blow-ups of certain expanded regions. You can see, and I've included, well, it's in the record appendix, these electropherograms that the defendants applied at the end of Volume 2, I believe. You can see all of the calculations and all the things that are made, the decisions that are made.
So your brother is incorrect when he tells us that there was a filter and there was a judgment call as to how to filter out what are anomalies or what don't count, and so that what you see are supposedly the alleles that are germane to the outcome or the opinion here? That is not what happened?
I am not saying there was not some judgment at the level of looking at the raw data. However, if you read just Robin Cotton's testimony, she talks about the filters that are normally applied, and that certain times there are notations or there are not notations because it is the practice to apply them. And these are stutter areas that are well known, that these analysts are trained to recognize. And so the difference between looking at the raw data and looking at the profiles that are shown on the electropherograms, including enlarged regions, and including the fact that if she had a question, as she said in her affidavit, she could make a call. There is not, that does not turn her into a conduit.
Are there protocols for how you make the determination that was made by the analyst here?
There were protocols. The degree of how they were written out, I would say, is somewhat unclear. It's not for every single thing, possibly, and that is fleshed out in the cross-examination, which lasted two full days, as far as Wendy McGee's ability to make a certain decision and Dr. Cotton's ability to understand what the decision that was made was based on.
But Dr. Cotton presumably wasn't there when the testing was done, when Dr. McGee did the testing. Let me just go on with this for a second, because it seems to me that what is at the heart of a lot of the concern expressed by Justices Scalia and Ginsburg, certainly in Bull Cumming, and we see it again in Williams, is that you don't get a chance to cross-examine the person who did the testing to get at issues such as interpretive bias, subjectivity. Here, for example, it was apparently available information that these were that a suspect had been identified, and that Dr. Greineder's DNA was available at Cellmark, and we don't really know what Ms. or Dr. McGee knew when she was doing the testing, and that wasn't something that anyone was able to get at through cross-examination of Dr. Cotton.
That is true, but I would ask the court to look at Justice Breyer's concurrence, where he talks about that mistake that Cellmark made, that the dissent talked about, and that wasn't, it's ambiguous whether that even came out through a cross-examination.
Why does Dr. Cellmark have to be or Dr. Cotton have to be the one that goes around the country testifying in these cases? Why couldn't McGee or the other two PhD supervisors, or there was another title that person, why couldn't one of them have come to testify?
The technical reviewers were unavailable, but I will say that they do not normally look at the raw data either. And if you look at the
but they're reviewing McGee's work right as it's being done.
No, they are not standing over her shoulder.
Well,
and that is laid out even in the Lopez, the Rhode Island Supreme Court case that came out only 4 days after Williams versus Illinois. So they didn't really analyze Williams versus Illinois except to say in a footnote it buttressed their opinion. That person says that the reviewer looks at the notes and the data, there are plenty of cases where they say, no, we don't stand over the shoulder of the person that's actually doing the testing. And
why couldn't McGee have been the person that testified here?
Why couldn't she, or why wasn't she? It's two different questions.
Well, start with why couldn't she?
Why couldn't she? I don't know. I think she was on the witness list, and as you see in the transcript, and as well as both parties have pointed out, the prosecutor said she may well be called when Judge Chernoff asked, is she going to testify?
Does Cellmark ever call any of these analysts
Yes,
to
they
testify?
do. In fact, there is a case going on in Norfolk Superior Court where the person that did the testing is testifying. And Dr. Cotton may also testify about the protocols and the policies.
Now, Dr. Eisenberg, I guess after the trial, apparently writes, and it's in the brief filed with us, that McGee knew Dr. Greineder's profile before she tested the evidence. Is that true?
The first submission to Cellmark had fingernails, and it had the victim's profile. The fingernails in the cover letter said fingernails of Dirk Greineder. The actual report just says fingernails. So yes, the knowns to the extent that this defendant became the person charged with this crime. But at the point that those were sent, he was not in custody, and the gloves and the hammer and the knife, it was not known. This is not like someone being arrested and then you test their blood alcohol, or someone being arrested with drugs and then you test the drugs. This is not an unknown rapist in the sense that the police had their suspicions about this defendant from the beginning. But the evidence that was sent, even though you call it a known, he was not in custody, and those gloves and knife could have just as well shown, and they did show a profile, an allele of an unknown, which
But in her report, did she compare the unknown from the hammer with the known from the fingernails?
yes, she compares
So
those.
she was doing a comparison.
But I mean, she doesn't compare them. We hope she didn't compare them while she is doing the analysis.
I mean, that's sort of the very crux of the defense position, is that when you have discretion in determining which alleles you're going to ignore, that you do have the potential bias of saying this, if this allele is real, it may or may not match.
Have the potential, but if that was the case, why would she have the stranger DNA? Why wouldn't she filter that out somehow if she was really going after this?
But isn't that the subject of cross-examination? I mean, isn't that the kind of thing that one would want to explore in cross-examination?
As far as whether she took the known samples and
Well, just to
compared
sort
them
of
while she's doing the testing?
testing the validity of her results.
Well, there is no suggestion that that was the case. It certainly could be something that could be asked on cross-examination, but that doesn't solve every problem. And
Let me just ask you, going back to Justice Cordy's first question, if after these cases you have, and you don't call Dr. McGee, how do you get, take as the assumption that, yes, the testifying expert can give an opinion about the connection between two samples and the likelihood, the statistical probability. But how do you get the underlying information about the underlying basis of that opinion in evidence?
what would be normally admissible anyway, the data, the underlying data.
Well, but you don't have McGee testifying.
You're asking how do you get it in?
Well, who explains how this works? I mean, I think one of Mr. Sultan's concerns is the opinion by itself is useless, he says, and therefore the Commonwealth should be required to have to introduce evidence that explains that opinion, and they can't do that if they don't have the right person.
Well, they can do it by saying this defendant is not excluded from the source of DNA on the glove, and the number of people in the population that could have the similar source are this many, 1 in 22,000 or something like that.
Expand that a little bit. What does the expert say? I looked at the DNA profile of a sample on a hammer, and I looked at a DNA profile of the victim, and they're consistent. I mean, what?
In this case or for future?
Well, in this case, what can they say in this case without all of McGee's underlying work in evidence?
Not what did happen.
Yes, without
what
the
happened?
underlying data.
Right. So how is this going to work?
After review and forming the opinion that the defendant is not excluded.
After review of what?
After review of all the underlying data, but it doesn't have to come in on direct examination.
So I reviewed the underlying data of what?
all of the profiles that were taken of the samples and of the known source. And then the comparison is made, is this person excluded? No, he's not excluded. You don't have to say because in 4 of 7 alleles there is a match. You just say he's not excluded. And the number of people based
So
on the population.
the samples will be in evidence, or is this all, I mean, she's saying, she will say, I reviewed the samples that were tested,
I reviewed
the
all
profiles of the samples. What is it she's reviewing?
She's reviewing, if she did not do the testing
Right.
herself, she's reviewing all the notes, all the data, all the electropherograms, all the blow-ups, the expanded regions, knowing what she knows about the filters that Cellmark applies and the bleed-through and the stutter and all of her expertise about artifacts and so forth. She's reviewed all of this, and she comes to the conclusion that this defendant is not excluded. And the basis of the statistics that shows that gives the jury some context for what that means is that 1 in so many quadrillion or 1 in so many hundred, and that's a number that they have to work with. And then on cross-examination, if the defendant wants to show the underlying, well, it was only 4 of 7, or what about this allele that was stranger, that didn't match the victim or the defendant, that is what can happen.
Okay, and have cases been tried in that fashion
Have they been?
since Greineder?
I can't speak for every case. I know that published decisions, but I certainly think that that's a viable way to continue with the rule that we have that is working.
Well, that's what our existing rule requires, isn't it? Just that kind of.
Yes, that is what it
Presentation.
requires. And Williams versus Illinois does not undercut that. In fact, it affirms that.
Thank you, counsel.
Thank you, Your Honors.